Good morning. Thank you very much for joining us for today's informational hearing on the Assembly Committee on Business and Professions on the examination for the planning for medical and non-medical cannabis regulation. The enactment of AB 243 and AB 266 and SB 643, known as the Medical Marijuana Regulation and Safety Act, created the needed standards for regulation of medical cannabis in California. We also know that, in addition, the November 8th passage of Proposition 64, or the Adult Use of Marijuana Act, provided additional standards for regulation of recreational cannabis. Currently, we are facing a looming January 1st, 2018 deadline for implementation of both adult use and medical cannabis laws. As agencies are charged with regulating cannabis, we want to make sure that we focus on the regulatory environment and ensuring that we have a clear process moving forward. Our purpose today is to talk about the oversight and the regulatory framework in the state of California as it relates to the Professional Licensing Board in this hearing today, so that we can try to find additional sunlight in this process. Of course, we'd like to thank the authors of the Act, particularly Assembly Members Wood, Bonta, Lackey, Cooley, and Jones Sawyer, and the chair of the Assembly Ag Committee, Assembly Member Caballero, for also joining us here later on today. I also want to recognize a few panelists from LAO and the Department of Finance who will be with us in and out throughout today, as I know that there are other Senate obligations as well, too. So at this time, let's begin with our first panel with respect to the history and purpose of cannabis regulations. And as they come up, we invite Helen Kerstein and Shawn Martin. And from the Department of Finance, because I know there are also challenges going on, we also asked Brendan Murphy to please come up and join us. And while those individuals are coming on up, I also would like to welcome committee members if they are interested in making any introductory opening remarks. So at this time, would any members of the committee like to have any introductory? Straight right into it? Wonderful. So welcome, Helen, Shawn, and Brendan. Please, whenever you're ready. And thank you very much for spending time with us today.
Thank you. Shawn Martin with the Legislative Analyst Office. I'd like to thank the chair and the members for inviting us here today to present on the history and purpose of cannabis regulation in California. And I will be presenting from a handout. You should all have a copy, but if you don't, I've brought extras so that one of the Sergeant-at-Arms could provide you with one. And I'm going to go in chronological order, starting with Proposition 215 that legalized medical cannabis. Then I'm going to talk about the Medical Cannabis and Regulation Act that created a regulatory structure for medical cannabis. Go on to talk about Proposition 64. And finally, I'm going to conclude with a brief review of the governor's budget proposals at the end of my presentation. So if you'll turn to page 1 in your handout, the voters passed Proposition 215 in November of 1996, and the measure made it legal for people to use medical cannabis. However, Proposition 215 did not create a statutory regulatory framework for cannabis or for taxing cannabis. So under Proposition 215, medical cannabis has mainly been regulated by local governments at the local level through ordinances, through permit requirements, and in local jurisdictions throughout the state that have imposed restrictions on the cultivation and sale of medical cannabis. Local jurisdictions have also imposed various fees and taxes on cannabis businesses, and while the state largely did not do that, they did regulate it did collect sales tax on some products. So turning to the next page in your handout, in 2015, the legislature passed AB 243, SB 643, AB 266, and also SB 837 in the Committee on Budget and Fiscal Review, and the bills passed by the legislature collectively known as the Medical Cannabis Regulation and Safety Act. And this created a new regulatory structure for the licensing and enforcement of the medical cannabis industry about 20 years after Proposition 215 passed. It assigned regulatory authority to a new bureau within the Department of Consumer Affairs. And if you look at Figure 1 in the handout, it shows you the the different departments in state government that are assigned to regulate some aspect of cannabis and what their responsibilities are. For example, the Department of Consumer Affairs licenses distributors, transporters, dispensaries, and testing laboratories. Food and Agriculture licenses cultivators, and they're also going to implement a track and trace system. And this system will place a unique identifier on every cannabis plant that's grown. You'll be able to track that cannabis through the system from when it's processed, when it goes to a manufacturer, or when it's actually sent to a dispensary for purchase. So that's one of the key things that the Department of Food and Agriculture is implementing at this moment. The Department of Public Health is responsible for licensing manufacturers. The Department of Fish and Wildlife is going to monitor and reduce environmental impacts of cultivation by working in collaboration with the State Water Resources Control Board, which is looking at the water issues related to cannabis cultivation. And both Fish and Wildlife and State Water Resources Control Board are working in collaboration with the Department of Food and Agriculture on those issues. And then finally, the Department of Pesticide Regulation is developing pesticide use guidelines for cultivation. So the MCRSA authorized regulatory agencies to collect fees to fund their activities and deposit these fees in a new fund. That's the Cannabis Control Fund. And it instituted a system for regulating, monitoring, and reducing the environmental impacts of marijuana cultivation. That's what I was just talking about. That's the Department of Food and Agriculture, Fish and Wildlife, and State Water Resources Control Boards all working together to do that. So if you'll turn your page, on the next page, Proposition 64 was approved by the voters in November of 2016. And it legalized use of non-medical cannabis for people 21 years old and older, and it created a regulatory structure for licensing and enforcement of non-medical cannabis, in many ways similar to the one created for medical cannabis under the MCRSA. For example, it assigned State Departments similar regulatory responsibilities to those that they were assigned under MCRSA, and that's what I just went over with you. It also imposed new state excise taxes on the cultivation and retail sale of cannabis, and the measure also excluded medical cannabis from portions of the sales tax if a person holds a valid medical ID card. However, there are some differences that exist between the MCRSA and Proposition 64, and I'm going to go over those with you, a few examples of that right now. MCRSA generally limits a medical cannabis licensee to holding state licenses in no more than two categories. So examples of licenses are cultivators, transporters, distribution, testing, where they test the cannabis to make sure that it's not contaminated by pesticides, manufacturing, and dispensing, or dispensing is also known as retail. So MCRSA generally limits a medical cannabis licensee to holding state licenses in no more than two categories. So they could hold a cultivator license and a manufacturing license, or maybe a manufacturing license and a dispensing license. I'm speaking in general terms. They couldn't hold more than that. In contrast, Proposition 64 generally allows a non-medical cannabis licensee to hold licenses in more than two categories. So under Proposition 64, they could hold a cultivator license, transportation license, a manufacturing license, and a dispensing or retail license. And that's sort of known generally as vertical integration, when you hold all those different licenses so you can control your product through from cultivation through sale. Now, it's also important to point out that for the testing license, if you hold a testing license, you can't hold licenses in any other categories, because that would be considered a conflict of interest. If you're growing and manufacturing and you're testing your own product to see if it's safe for consumption, that would create some dilemmas for people if their product tested badly and it wasn't fit for sale. They'd be, have a conflict of interest potentially. Independent distribution, so distributor licensees under the MCRSA generally required to be independent entities that do not hold licenses in other license categories. In contrast to distributor licensees under Proposition 64 generally can hold licenses in other license categories. And then also verification of local permits under MCRSA requires state license applicants to provide proof of a local permit when they submit their application to the state for the license. However, Proposition 64 prohibits the state from requiring applicants to provide proof of a local permit or permission to operate. However, Proposition 64 also prohibits the state from issuing a license if it is in conflict with local ordinances or other laws. So now I'm turning the page, and we're going to talk a bit about budget trailer bill legislation. The administration proposes various changes largely intended to reconcile the differences between MCRSA and Proposition 64. So in April 2017, the governor released a trailer bill legislation that creates a single regulatory structure for medical and non-medical cannabis. It was thought that if you had separate regulatory structures, one for medical and one for non-medical, this could lead to a lot of confusion. So the legislation generally uses Proposition 64 as its foundation, but it does include significant portions from MCRSA. For example, it includes the section on track and trace from the MCRSA that was in SB 643. Also, the legislation proposes other policy choices that are not included in either Proposition 64 or MCRSA. So some changes to Proposition 64 can be made by the legislature as you're looking at reconciling MCRSA and Proposition 64. Proposition 64 allows for modifications to framework of non-medical cannabis by a majority vote of the legislature. Modifications to most of Proposition 64's other provisions, such as those related to taxation and criminal offenses, require a two-thirds vote of the legislature. And under the measure, any legislative changes must be consistent with the proposition's intent. There are some changes, if they're not consistent with Proposition 64's intent, then you would have to go back to the voters for approval. So turning now to the last page of the handout, this provides a table that summarizes the governor's 2017-18 budget, including the January and May proposals. Figure 2, these proposals would add to a previously approved funding and positions and would provide state departments with a total of $118,527,000 positions in 2017-18. The proposals are mostly funded from the Cannabis Control Fund, using loans from the General Fund, as well as various other special funds. So that was all that I was going to present today. We'd be happy to answer any questions for you if you have any. Thank you.
Thank you very much, Shawn. Any questions at this time for Department of Finance? No? Mr. Cooley?
I have two questions, and it gets, one is a fiscal issue. I'm interested in sort of the tax impacts of Prop 64, how it's structured. And they have an exemption on the tax for persons who have the valid doctor's recommendation for medical marijuana. Under existing law, since John Vasconcellos' bill, SB 420, you've needed to get the medical ID card. Medical ID card, you take a doctor's recommendation, but there's some additional hurdles you have to get over at the county level to get that ID card. It's portable, it could go out of state, but the key issue to me is, since we are creating a tax window for holders under Prop 64 of the medical recommendation, and it's easier to acquire, do you have any opinion on how porous this tax exemption for the medical may get under the 420 system, where you actually have to get your recommendation, go to the county, get the card, as opposed to simply getting a doctor's recommendation? I'm sort of concerned about the tax impact of that. And I have one other question.
Helen Kerstein from the Legislative Analyst Office. So we do believe that it's likely that there could be some sales tax implication related to the trailer bill, which would, as you indicated, change 64. So currently 64 says you can get that sales tax exemption if you present the valid medical ID. As you mentioned, that's an extra hurdle. It's probably harder to get that. So probably fewer people will qualify for that sales tax exemption if 64 is left as it was written. If the trailer bill is ultimately adopted that's been proposed, that would change that and get rid of the medical ID system. We do think that'll make it somewhat easier for folks to qualify for that sales tax exemption. So there certainly could be an impact on sales tax revenue.
Very good. The other issue I just wanted to raise, I'm very interested to be supportive of the implementation of Prop 64 by hitting its target date. You mentioned track and trace. There's a question in my mind whether that'll be ready on January 1st. But on this issue of supporting its implementation, I have to confess to be very concerned. I think the writers of Prop 64 were very clear that they were looking to consolidate the medical marijuana statute and Prop 64. They describe it in the body of their proposition and its key provisions as one agency administering both Chapter 3.5 and the new thing. There are several dozen references throughout Prop 64 to Chapter 3.5, which just says to me it was fundamental to the whole conception. The intention provisions, the purpose sections have several dozen references that distinguish non-medical from medical. So I see a statutory scheme where the two are kind of kept apart, even down to the level of what is marijuana for purposes of the Act. It distinguishes medical from regular marijuana. So I'm kind of concerned that in this jump to schmooze these two things together, that actually is walking into a trap, because it would be easy, I think, just by citing the law itself within the four corners of Prop 64, to say that you have made a system of amendments in conflict with the basic structure as presented to the voters, which would be a major setback to implementation. Any thoughts on that issue?
So I would note that we're not attorneys, and so certainly perhaps the Ledge Counsel would be able to provide a more definitive legal interpretation in terms of what would be possible under Prop 64 in terms of amending that, or in terms of reconciling that with MCRSA. As you mentioned, Prop 64 does include references to MCRSA, but you could imagine, even if you did want to reconcile them, the way that it's currently proposed is basically taking 64 as a foundation and then making some modifications, adding a bunch of provisions, including those from MCRSA. But you could imagine you could create parallel statutes if there was really concern about sort of potentially changing those code references. But I'm not sure whether that would be a significant legal issue or not. I think that's perhaps a question that Ledge Counsel could opine on.
Thank you.
Thank you very much. Mr. Jones-Sawyer.
Thank you. Would the Bureau benefit from some type of sunset review? I've served in the city of Los Angeles for like 25 years, and voters would come up with some program or try to build a bridge or whatever, and they would form a committee to look at how do we build bridges, and they would, gather all the money they can, and then that bridge is built. But that committee is still there, meeting for God knows whatever they're meeting for, because the bridge is already there. And this goes to the fact that many of us here are serving 12-year terms, not 6-year terms. So accountability, reviewing state agencies is probably be more important now for us over a 5-year period or an 8-year period or a 10-year period, so that the purpose of why the original Bureau was set up, one, it maintained, but if I'm not necessarily saying that we would eliminate it, but maybe we would add some things and look at whether or not 5 years from now their goals and objectives match what present day things are happening. So would having a sunset review for the Bureau benefit?
So from our perspective, the sunset review process is a very valuable process for the boards and bureaus under DCA. It really does provide quite a good level of oversight, and it really lets the legislature review in depth their operations and make sure that they're still performing the functions in a most efficient and effective way. So certainly I could imagine there being some role, whether it's a sunset review process per se or whether it's some other kind of legislative oversight hearing process for the legislature to have a similar type of oversight over this new bureau. You can imagine that there's a lot that they're going to have to undertake, and it's going to be challenging, and they're going to be probably benefiting even more than other entities from legislative oversight. And we think it's really important, for example, that they report back in a variety of different ways on a regular basis to facilitate oversight. But certainly hearings and some kind of review process, whether it be the formal sunset review or some other process, could have a really important role, I think, in ensuring that this is a really successful new endeavor that the state undertakes. So I think that's a very important point.
Okay. Thank you.
Mr. Gibson.
Thank you very much, Mr. Chair. Question for you. In this new era that we find ourselves in based on what the voters have approved, one, is staffing adequate enough to take on this new challenge moving forward? Because I see staffing, us going in this new era and creating positions and department and new bureau. Is that an issue? And if so, can you elaborate on some of the challenges that you foresee?
So certainly there are quite a number of positions and quite a few resources, as you saw on page 5, that are being proposed. I think it's a really open question whether these are sufficient or perhaps too much. I think we don't really know for sure at this point. I mean, there's so much uncertainty in terms of the ultimate resources that are going to be needed to implement this regulatory structure. I don't think we know how many licensees we're going to have for sure. We don't know how much workload it's going to be. We know it's going to probably be a lot, but whether it's going to be, how many thousands, I think is still an open question. And we don't really know exactly how much workload it's going to be. And part of how much workload it's going to take to license and enforce against these folks is going to depend on the ultimate regulatory structure, both as passed in the trailer bill, as well as whatever regulations, which I know there are draft regulations on the medical side that have been proposed, but really how those play out, as well as the ultimate regulations on the non-medical side, could have some impacts as well. So I think our office has really emphasized that there is a lot of uncertainty here. So one of the things that we've suggested is basically approving the 17-18 resources, but taking a more incremental approach in terms of the out years and really revisiting this, because I think this is going to be something both probably on the statutory side, but also on the resources side. I think the legislature is going to have to revisit this probably, a number of times over the coming years and adjust. And there might be some departments that got too many resources and others that got too few, and there are probably going to need to be adjustments that are included there. And I would note that there's some provisional language that's been proposed, at least for public health, and I know there's been discussions of possibly including some similar provisional language for DCA that would allow them to hire some additional folks even beyond those that are proposed. So I think that folks are actively thinking about this and trying to figure out what's the best way to make sure these departments have the resources they need and don't have too many resources approved in perpetuity that aren't needed. So it's a balancing act.
Thank you very much.
Mr. Grayson.
Thank you, Chair, and thank you for your presentation this morning. On page 3 of the report, you had brought out some key differences, and I can only at this point assume that those differences may be of concern simply because you're bringing them out as key differences. The vertical integration, independent distribution, verification of local permits. Are these a concern because they are key differences? So are they a concern? And if they are a concern, are there recommendations of how you would address them, and then even furthermore how that could be accomplished through legislature? And the reason why I bring this up is because are there other industries that are that face some of these same regulations, for instance, other industries where they may seek the state for license, but they have to show a permit locally. Is that existent in other industries where if that isn't fixed in this one, then maybe maybe there's a difference that they're getting a bit more of a favorable process in this particular industry? Does that make sense?
So we would note that these are a couple of the differences. There are actually quite a number of differences. These are probably some of the most significant. I think overall, our office's view is that it does probably make sense to reconcile as much as you can the statutory structures, whether that be in one set of set of code or whether you have parallel codes. Just because I think it could be a little bit on the confusing side and could be not quite as efficient to have two separate organizational structures. If you could own these two businesses in this structure and you can own these 5 on that structure, it might be more complex. So I think overall we do think there's value in trying to have a consolidated approach. I think in general, in terms of the vertical integration and independent distribution aspects, our office in general leans towards not creating more impediments to the market structure unless there's really a compelling reason to do so, like a health and safety reason. And so I think in general, we would favor not requiring an independent distributor and not requiring folks to only hold 2 license types, with the exception of the testing labs, as Shawn mentioned, that there really is a strong reason for having those separate, but that's proposed under both models. In terms of the verification of local permits, I think there may well be there's a sort of a proposed approach that the Department of Finance has to trying to address the issue that Prop 64 has, where basically it requires the state to verify compliance with local laws and ordinances, but doesn't allow the state to actually get the license or the proof of a local license. We think there's probably a more direct approach than what they're proposing, because they're proposing sort of a multi-step process that involves some CEQA exemptions and kind of some things that are a little bit complex, and we think there might be a more direct approach. With regard to, I think you were asking if there are other entities or other businesses that require that local permit before the state issues a permit, and I'm not aware of any, but perhaps Finance is more aware of it.
All right, thank you.
I'm not aware of any.
Mr. Cooley.
Related to the comments I just heard, I wanted to share last Thursday and Friday, there was a National Medical Marijuana Conference. Last year in Boston, it was in Berkeley this year. Probably a good site for a marijuana conference. Thursday was legal panels. You had lawyers from around the country talking about medical marijuana regimes in all kinds of states. Thursday was more focused on the therapeutic uses of medical marijuana. And the thing that struck me in the 2 days, the most outstanding observation was that all the other states speaking said that as commercial rolled in, it sort of squeezed out attention on the medical. And we even had our own director of the Medicinal Cannabis Research Institute at UC San Diego, as well as other UCSF professors, focusing on this loss of attention to medical marijuana when the commercial rolls in. They expressed medical concerns with that, scientific concerns with that, because from a medical science standpoint, the active ingredients in marijuana that have distinctly medicinal effects are different than those that produce the psychotropic effects, so you really need to keep them apart at the scientific level, and that dosing levels for efficacy. So when I put those observations together with this conversation, I can see how over time sort of moving towards consolidation makes sense. But I also think on behalf of the voters who supported 215 and seeking medical relief, and this was another facet of the research, they went through a lot of the research studies, and the observation was it's striking how all the evidence converges. It shows the efficacy for spasticity, for pain relief, for all manner of conditions. It is a better medicine and doesn't have some of the side effects of opiates and things like that, opioids. So it just, to me, was sort of highly admonitory to kind of think through the pertinence of keeping the two bodies of law sort of separate while we work things out, and to make sure that we maintain affordability. And on that issue, I do want to note that both these measures have advisory commissions, which I think is to the good. But as a part of the Medical Marijuana Act, that advisory commission was all about access, affordability, supporting affordability, which the advisory commissions under 64 are more dealing with commercial implementation issues. So I sort of am sympathetic to the idea of merging over time, but I think people who pass Prop 215 have an expectancy, and honestly, people for whom it makes a difference in their lives, quality of life from a medical standpoint, really need champions here. Thank you.
Thank you very much, Mr. Cooley. Any additional questions or comments from any members of the committee for our representative from the Legislative Analyst Office? Seeing none, thank you very much. We'll now also turn from the Department of Finance. Brendan Murphy.
Thank you, Mr. Chair. Committee members, appreciate you having me here today, and apologize for my time constraints. So I'm just going to briefly summarize the trailer bill at a very, very high level. I know you guys have a much more detailed handout in front of you. So committee members who don't know, I apologize, I have to be in Senate full budget in about 24 minutes. So I'm going to keep my comments as brief as possible so you guys can feel free to ask your questions. How about that? It's generally the first priority of the administration implementing the new regulatory system excuse me, that will govern cannabis industry in California is to protect public and consumer safety. The administration also seeks to safeguard local control over the industry and that the industry complies with all of California's environmental laws. Implementing a new state regulatory system for medicinal cannabis was a significant undertaking that was made more complicated by the legalization of adult use cannabis this past November. That overlays a separate and different regulatory structure for the cannabis industry. As the state moves forward with the regulation of both medicinal cannabis and adult use, one regulatory structure for cannabis activities across California is needed to maximize public and consumer safety. Furthermore, implementing the statutes separately would result in duplicative costs and inevitable confusion among licensees, regulatory agencies, and the public. While many components of the regulatory structure are proposed to be harmonized, the administration proposes to preserve the integrity and separation of the medicinal and adult use industry by maintaining these as two separate categories of license types with the same regulatory requirements for each. The amendments proposed by the administration seek to clarify and enhance both Proposition 215 and the Adult Use of Medical Marijuana Act, as well as MCRSA. As passed, excuse me. Although California has chosen to legalize cannabis, federally it remains an illegal Schedule I drug. Protecting against illegal diversion of cannabis inside and outside of the state is an important public safety issue, which is why the state is implementing a robust track and trace program that will track all cannabis from seed to sale. Furthermore, to protect public health and safety, the state has assumed some food and drug responsibilities that would normally fall to the federal government. These duties range from creating pesticide use guidelines for cannabis to standardizing tetrahydrocannabinol levels in a product. The safety of the product is not dependent on whether it is purchased for adult use or medicinal purposes. This distinction becomes important only at the point of sale, where different age restrictions and sales taxes apply. Thank you.
Thank you very much for that. Mr. Lackey.
Yeah, I have two quick questions. First of all, why did the Prop 64 structure the harvest tax the way it did? For example, I'll be very specific, because it seems to me that a cultivator could be forced to pay taxes on products that couldn't be sold because they didn't pass the actual testing.
So I guess part of your answer, sir, is it's probably a great question for the Prop 64 panel as well. But I don't disagree with the interpretation. I think the original hope in the trailer bill was to clarify that through regulations as to exactly what level and when the tax is paid. And that's kind of what the trailer bill took into account. And I don't disagree with you that there's a way that statute can be interpreted that could say all cannabis grown it's applied to, rather than what's entering the commercial marketplace.
And my second question also is appropriate for the next panel, but I wanted to catch you before you left. Why does the administration propose eliminating the medical cannabis patient ID card? It seems like that won't using doctor recommendations put patient privacy into jeopardy, because the dispensaries will need to keep the documentation with private medical information. And by the way, speaking of ID card, you might want to turn your ID thing around.
Oh, I don't have one. This is
it's
a
just
note.
a tease.
Yeah. Yeah, please state your name for the record. So I apologize for not doing that.
Okay.
Probably fair. I should have remembered that as well.
It's all good.
So, sir, I think the first part of this is that the medical ID card originally, as originally proposed, was never required to purchase cannabis from a dispensary. So the medical ID card, as proposed, as Assemblymember Cooley mentioned earlier, it was an option for patients. It was not a requirement. Right now, the participation rate of that is significantly under 20% of the patients known in the state. Probably actually hovers in the low teens. So the doing away with the medical card was really more a reflection of a program that hasn't had the effect that I think it was originally intended under the original legislation. And what you have now, as far as patient identification, is that most provide their note from the doctor directly to the dispensary already. So that's not changing kind of what is for over 80% of the patients right now, their common practice.
Okay.
Mr. Cooley.
To jump down into the weed for a moment, as a part of the proposal, you have proposed limiting Type 3 cultivation licenses. So the question is that consistent in your view with Prop 64? Or if we start limiting a type of license in Prop 64, do we need to go back to the voters to do that? Interested in your thoughts on that.
So, yeah, we proposed it because we felt it was consistent with Proposition 64. However, I too, as the LAO mentioned, am not an attorney and would not opine on the exact legalities. We did check from our side, and we believe that is consistent with Prop 64.
So does that open up the prospect that we might impose other limits on other license types?
Yeah, I mean, I potentially in the future, yes. I think at this point in time, we only have one, and that's where we're at right now.
Okay. Could you also comment then on you exempt the CDFA from taking actions on a licensee who violates Fish and Wildlife or Water Board standards. What's your plan for enforcing those standards if CDFA doesn't have enforcement actions? Just what's the thought on that piece?
So I think the section you're referring to is actually a bit of a misnomer because it's covered in other sections. So the reality is that CDFA has in the trailer bill has the full right to take action on any licensee on the cultivation side that is not living up to their environmental rules and regulations. However, in many of the grows, both CDFW and the Water Board will have a pre-existing permit process that has to go on. So without that permit, you won't be able to get the cultivation license. So there's a bit of a back and forth, right? So if they're found to be in violation of the original permit, then yes, the license would be eligible for suspension because you would no longer have access to your original permit that the license was approved upon. So there's more than one section that deals with this aspect of law, and it is not. There is still enforcement action for CDFA on anybody not living up to the environmental side of the law.
So CDFA, in your view, has full power to take enforcement actions against someone for violating a Fish and Wildlife or Water Board standard, independent of the licensing, just because those are the rules. If it comes to their attention, they can move aggressively on it.
Yes, you would have that ability. The other one was it would be a coordinated approach, right? So you would also have the ability for Fish and Wildlife to say, no, they've violated our permit. Let us move first in some sort of formal action, or at least through their normal active process that may not require CDFA to immediately suspend the license, but would be something if, for example, the person who's being acted upon, the licensee who's being acted upon, does not then perform a remediated action as asked for by Fish and Wildlife or Water Board, then at that point maybe you would have them request CDFA to take full action on the licensee.
Thank you, Mr. Murphy.
Mr. Wood and then Mr. Downey.
Thank you. I have a couple questions, Mr. Murphy. First of all, how will the Bureau handle transportation since it wasn't included in Prop 64? Will it be limited to between licensees? Will there be a minimum standard? Are you going to require everyone who transports to have a commercial license? Can you help us with that? Because we're a little unclear.
So transportation is definitely one of the aspects of Prop 64 that is expected to be further clarified in regulations as we move through, finish with the trailer bill and move into the Prop 64 world. It does allow for the Bureau to further clarify and define those in regs. I would preface that I know you were on the phone call. You've seen the regulations for the MCRSA, and I would expect that we would continue those through as far as transportation aspects as we move forward. I don't think there's going to be some sort of sea shift. I mean, I think the things that we've already kind of clarified in regulations would be same types of things we're going to look at as we regulate transportation in Prop 64.
So the question was, will there be a license category for transportation?
No.
There will not.
Not at this point. There is not one. There's not one that's identified. There's not one in the trailer bill. So at this point, there would not be a license for transportation.
So there will be but there will be requirements on how things are transported. Will individuals who are transporting be required to have a commercial driver's license? I don't recall if that's in the
we would cover that in regulations.
So that's pending at this point.
And not statute?
At this point in time, it is not proposed in the statute. No.
That would seem unusual.
So second question, completely different subject. And Prop 64 says that the administration, quote, shall not reduce the general fund appropriation to the Department of Fish and Wildlife, Department of Parks and Recreation, below levels provided in the Budget Act of 2014. But in the May revise, the general fund allocation of is over $9 million short of that threshold. How do you justify that?
That's an interpretation issue. So that section is actually covered. The interpretation that we have is that when taxes start and as the tax revenue comes in, so June 15th of next year, basically a year from now, Finance's role is to make an estimate of what the tax revenue will be over the next year as far as expenditures, and at that time, that is the time when Fish and Wildlife must have the 2014 level.
It feels a little bit like Prop 56 all over again, quite frankly. It feels like an interpretation that's in violation of a citizen's initiative to take money that the people voted a specific cause for and take it away. In this case, $9 million from the Department of Fish and Wildlife. I would love to hear what the supporters of the initiative feel about this. I think it's wrong, and I'd really like clarification because I don't buy the explanation. Do you have anything else to add?
No, sir.
Wow.
Mr. Daly.
So for my district, we have a lot of the grows are out there, and there's a lot of fish and game violations. And so what's the staffing levels? Have you increased any staffing levels? Because the current staffing levels are not adequate to address the issues that's with the environmental degradation that's happening in, I know, Assemblymember Woods and my district alike. So basically enforcement.
I apologize. I'm going to try and get to my notes for the next hearing in 15 minutes. So Fish and Wildlife in the mayor vision has proposed $17.2 million from multiple fund sources in 63 positions, a significant portion of which is for enforcement actions in those areas, which builds off of their existing staff, as you know, from the existing teams that we're taking illegal grow actions currently. So just to give you kind of a ballpark of the total proposal, and this is broader than just Fish and Wildlife, so I apologize, but I have the big numbers right in front of me here. 26.7, reverse those numbers. I apologize. Clearly I'm not ready for budgets yet. $27.6 million is proposed in total to be spent on enforcement in the upcoming budget year. So there's a significant investment of enforcement across all license types and in all areas.
Mr. Sally, did you have any additional comments?
So, how many FTEs did they actually add? Did they add, or is it this? the same people doing
No,
more work?
63 are new positions at Fish and Wildlife.
And that's going to be targeted towards doing cannabis.
Yeah, both enforcement and licensing staff related to that permit process I discussed earlier.
All right, thank you.
Mr. Wood, did you have a follow-up?
Well, I'm just curious, in light of the fact that the $9 million is being taken away from the department, where does that play into that $26 million? Are they completely separate?
Yes. Yeah, so the money being added is both a mixture of fee revenue at the department as well as cannabis control fund.
Okay. Through the chair, could I ask one additional?
Please.
Well, so, how does the administration plan to help create a level playing field for small actors, small businesses, diversity within businesses?
I think there's still many discussions at this point going on in relation to the trailer bill about exactly how the correct and probably best way is to recognize that small businesses have a very defined and distinct role in this industry and have been a major part of making this industry legal at this point in time. So I just would assure you that yes, that is an ongoing part of the discussion and is something that we're absolutely aware of and would like to ensure that we have an appropriate trailer bill that crafts an ability for all businesses to participate.
Okay, thank you.
Mr. Ponte.
Thank you, Mr. Murphy, for your time. I know that your time is compressed and appreciate your candor in response to the questions of the committee. I just wanted to raise the issue of non-storefront dispensaries with you, something that I don't believe made it into the final trailer bill language, but is a concept that has been discussed and I think can really be something that can be helpful to patients with mobility challenges, also good for public safety in the sense that there's a central location, a physical place for inspection and monitoring. Can you share your thoughts on why that didn't make it into the trailer bill language?
I think rather than going back in time, how about I go forward with you? That's an area that is still in ongoing negotiations, and I think that we're trying to refine that process as we move forward, and understanding that the business has many facets to it, and sitting in Sacramento is not the necessarily the easiest way to create a regulatory package for everybody, and I think that's an area that there's still negotiations ongoing about exactly how we look at and how we categorize non-storefront operations.
Through the chair, if I may, thank you for that. It sounds like you're open-minded as to what the future of non-storefront dispensaries might be. Of course, while the trailer bill language is a part of the budget process, it's certainly chock full of a lot of policy, and a lot of the members on this committee are working on a bill that proposes a non-storefront dispensary concept. If I understand your comments correctly, you haven't closed the door on that idea. It's something that you just weren't prepared to include in the TBL at this time.
Yeah, absolutely, sir. And I think that's a good discussion point. Has been a discussion point as we move forward.
Thank you.
Any additional questions or comments at this time, Department of Finance? Great, seeing none.
Thank you very much. I apologize for the demands on my time today.
Yes, thank you very much for your time. Yes, and thank you very much for being here as well. We'll now move on to our second panel, examining the legal impact of amending existing cannabis laws. I'd like to now call up Diane Boyer-Vine, Jason Kinney, and Richard Miadich. Ms. Boyer-Vine, would you care to begin?
Good morning, Mr. Chair and members. Thank you for inviting us today. I'm Diane Boyer-Vine, and I have to my left Mariko Catani and Lucas Mateo. They're both here to answer specific questions you might have about public proposals and how we're dealing with them in the Prop 64 world. I think I'm here to talk to you generally about how Ledge Counsel deals with initiatives and specifically how we've dealt with Prop 64. So when we're asked in Council to work on statutory language that's been added or amended by an initiative, we have a very complicated analysis that we have to undertake. We start with the California Constitution, specifically Subdivision C of Section 10 of Article 2, which basically says the legislature may amend or repeal an initiative statute by another statute that becomes effective only when approved by the electors, unless the initiative itself permits amendment or repeal without voter approval. So first we have to determine under that concept whether an initiative, whether actually a proposed change from the legislature amends an initiative. Then we must determine whether the initiative in question allows for amendment without going back to the voters. If it does, then we must determine under what circumstances those amendments are authorized and whether the amendments in question meet those circumstances. And that all goes to our keying of a bill and perhaps a cover letter back to your office. We also have a role as your counselor to make sure that whatever we do is going to withstand judicial scrutiny. So you have to understand that the courts bend over backwards in this state to protect the initiative process. And I think in that regard, there's a quote from the Supreme Court in People versus Kelly, which dealt with the medical marijuana initiative that's probably instructive. And I quote, "In this vein, decisions frequently have asserted that courts have a duty to jealously guard the people's initiative power and hence to apply a liberal construction to this power wherever it is challenged in order that the right to resort to the initiative process be not improperly annulled." So as we're keying bills, we have that in our mind. And we also have to decide what's an amendment. And that's actually guided by case law. Franchise Tax Board versus Corey is one that says an amendment is any change in the scope or effect of an existing statute, whether by addition, omission, or substitution of the provisions. So once we've gone through all that, we look to see whether the legislature may amend an initiative without voter approval. So turning to Prop 64 specifically, I'm sure you're all familiar with Section 10, which provides either a majority vote to amend the provisions of the Act that are contained in Sections 5 to 5.5, dealing with the use of medical marijuana, and Section 6 to 6.3, which is marijuana regulation and safety. They may do that by a majority vote to implement the substantive provisions of the sections, provided that the amendments are consistent and further the purposes intent of the Act as stated in Section 3. The measure goes on to provide for a two-thirds vote to further the purposes. So when you're talking about a majority vote, we've made some determinations as to what implement means and what we're looking at in terms of intent. For us, implement means to accomplish or give practical effect to an identifiable substantive policy goal established in one of the sections. And then talking about intent. So generally when courts are looking at the intent of an initiative measure, they give it a broad view. In this case, the drafters were very specific that as to the majority vote, you have to look to the intent specified in Section 3 of the Act. And we think a court would give credence and to those words. They don't believe in idle acts, and they're very specific about Section 3. So when we are looking at a measure that's impacting the provisions of the adult use initiative, we're looking at Section 3 for the intent and purposes. That gives you a little bit of view of how we're dealing with it. There's also a complicated amendment process related to the rev and tax provisions. I'm not going to get into those. We also would note that Prop 64 was a measure that was drafted with much more detail than most initiatives that we see out there. And it was modeled after the medical marijuana provisions that were enacted by the legislature. And so that level of specificity actually makes our job almost a little bit more difficult at times to figure out how we're going to key it. So that's my general explanation of keying. If you have specific questions about proposals, we're happy to answer them. And Mariko and Lucas are probably better able to, because they've seen so many of these at this point, to talk about them.
Thank you very much. We'll then turn over to Jason.
Chairman Lowe and members, I'm Jason Kinney, the chief spokesperson and one of the lead consultants for Prop 64, as well as the newly formed C3 Californians to Protect Proposition 64. Thank you for the opportunity to address this important legislative policy committee here today. From our perspective, it is not only appropriate, it was anticipated from the beginning. We knew that marijuana legalization, while a long overdue public policy imperative with overwhelming public support in California, is not something that would occur in one election. It would evolve over a multi-year time horizon as lessons were learned, policy was put into practice. We also knew that this legislature would be a critical working partner in this process. Proposition 64 was developed over an 18-month period with the input and expertise of hundreds of California organizations and thousands of stakeholders. It began by adopting principles of the California Blue Ribbon Commission on Marijuana Policy, chaired by Lieutenant Governor Gavin Newsom. It met the Federal Department of Justice guidelines and was ultimately amended to serve as the adult use counterpart to the Medical Cannabis Regulation and Safety Act passed by this body. It was supported by the largest coalition of California organizations ever assembled in support of a cannabis measure, including physicians, environmentalists, labor unions, business organizations, social justice groups, endorsed by 10 of 12 major newspapers in our state, passed by the largest margin of victory by any marijuana legalization measure in our nation's history. We also note that this was the first marijuana legalization ballot measure to fully recognize and protect local control, including time, manner, and use authority, which is why we were able to secure, for the first time, a neutral position from League of Cities, CSAC, urban counties, and rural counties. Going forward, our focus is on ensuring that the state implements Prop 64 as written and approved by voters, including access to licensed commercial markets by January 1st, 2018. And for the sake of efficiency and to reduce public confusion, we specifically allowed for and support efforts by this administration and this legislature to conform the regulatory frameworks under both MCRSA and Prop 64 where feasible.
Thank you very much. Mr. Miadich.
Good morning, Chairman Lowe and members. My name is Richard Miadich. I'm the managing partner of the law firm of Olson, Hagel, and Fishburn. Our office served as counsel to the Yes on Prop 64 campaign, and I was one of the lead drafters of the initiative. Thank you for inviting me to speak with you today. In approving Prop 64, California voters enacted a series of laws that are intended to eliminate the illegal market for cannabis in California and replace it with a regulatory system to control, regulate, and tax cannabis for adults 21 and up. The purposes and intent of Prop 64, which are identified in Section 3 as mentioned by Legislative Counsel, state that the initiative is intended to accomplish several policy objectives. Among them, strictly controlling the licensing and operations of cannabis businesses, establishing and enforcing environmental protections, product safety standards, and workplace safety policies, and reducing barriers to entry into the legal market, requiring strict packaging, labeling, and testing of adult use cannabis, preventing minors from accessing cannabis, including banning edibles that are appealing to children or easily confused with regular foods or candies, and requiring packages to be child resistant, prohibiting cannabis businesses from advertising or marketing towards children, preserving local control by allowing local cities and counties to ban commercial activity in whole or in part, and that includes delivery, and to regulate those cannabis businesses they do allow through local licensing, zoning, and other local powers. Preserve existing laws that make it illegal to drive while impaired from cannabis use, and preserving existing legal rights of public and private employers to adopt workplace policies on cannabis. Generating up to $1 billion per year in new state revenues annually for restoring and protecting the environment, drug treatment and prevention programs for young people, community investment, and law enforcement. And finally, to enact criminal justice reforms to reduce penalties for nonviolent cannabis offenses and redirect young offenders to community service and drug treatment programs. The regulatory structure envisioned in Prop 64 adopts many aspects of the regulatory structure that this legislature and the governor enacted in 2015. By empowering the same state agencies and officials that regulate medical cannabis to regulate non-medical cannabis, the proponents sought to maximize state resources and assist the state in achieving the initiative's requirement to begin issuing state licenses by January 1st, 2018. One of the best practices that we identified during the drafting process, including through our review of the Lieutenant Governor's Blue Ribbon Commission on Marijuana Policy, was to provide flexibility in the regulatory structure. That's particularly important considering that we're doing an initiative, and as Ledge Counsel mentioned, typically initiatives are very difficult to amend if you can amend them at all under the Constitution. One layer of the flexibility that we provide is to the state agencies with authority to implement the initiative through regulations. In addition to that, the proponents wanted to ensure that the legislature did have the ability to refine Prop 64 based on experience with the emerging cannabis market, and therefore included specific authority for the legislature to amend the initiative, provided such changes are consistent with the purposes and intent of the initiative and meet specified vote thresholds. I want to thank you again for the opportunity to be here today, and I'd be happy to answer any of your questions. Thank you.
Thank you very much. Any questions? Mr. Cooley.
This is for Jason or Richard. I certainly see in the drafting of Proposition 64 an effort to kind of establish a workable structure, given the legacy law, Prop 215, the McCursa, and then the adoption of this. At the same time, from a substantive standpoint, as has been pointed out, the ability to amend is tied to Section 3 purposes. And when I sit there and look at, my review of Prop 64, Section 1 we've got the title. Section 2, you have some intent provisions, the first one of which is about recreational use. The second one of which is highly laudatory about the legislature's work in 2015, but includes the all-important line that with respect going forward, you will try to consolidate and streamline, which is to me where I sort of see the footprint for trying to bring them together. But then you get into Section 3, and there are 18 occurrences starting today running down through there. Non-medical, 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 non-medical. Anyone reading the all-important Section 3 will have a strong impression that this is a measure that focuses on non-medical marijuana. Section K, again, is very laudatory about the bipartisan work in 2015. And then again, non-medical, 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 non-medical. When you get into the substance of the bill, the definition of marijuana excludes medical marijuana. So again, we have an act within its four corners, I think, testifies and presents itself as focused on the non-medical side. This becomes important based upon the conference I was at that talks about how do we safeguard the interests of the medical persons who need the medical, have access to it, affordable access to it. You have all of these pieces that sort of fit together. It seems to me that Prop 215, having as direct democracy, delegated to the legislature to establish rules, which we did in 2015. I see nothing in Prop 64, though you had ample opportunity in the drafting, to say that we're going to undertake to redo that delegation. To the contrary, I see in Prop 64 maintaining a sharp differentiation. So I'm left with a concern, since as I say, I actually am supportive of implementing Prop 64, that the basic structure that has come from the governor's office to kind of put these two things together to repeal the underlying statute, there are almost 36 occurrences of that verbal formula, Chapter 3.5, Section 19200, et cetera, which is running through the statute. I just sort of feel we are being presented with a structure that on its face invites a legal challenge because it undermines kind of the medical scheme that was delegated to the legislature, we followed up on, that was designed to safeguard things. I just don't see what the rush is to put it together, and I don't actually believe within the four corners as drafted that it supports that. And I sort of feel for proponents of it, that is almost reckless. It's an invitation to a legal attack. I'm sort of interested in your observations or response to that.
Well, I'll begin by saying that you're absolutely right that it was our intention to protect and preserve the hard bipartisan work that was done by this legislature and the governor in drafting the McCursa rules and regulations. And we also believed, based on our studies in other states, that that the best way to strengthen a medical marijuana marketplace for legitimate patients was to create a open, licensed, overseen, and regulated adult use market for non-patients. So we endeavored to create a structure that protected McCursa fully, but at the same time, what we've seen in other states is that in the implementation oversight of a regulatory framework, that there are inherent inefficiencies, there's public policy rationales given public confusion, that there are places where you want to align or conform the two systems. Right. Purely binary systems have failed in the states where they've been attempted to been implemented. And so we attempted to give, knowing the dynamics of direct democracy, which is, you get one shot at your best effort to do it right. In this case, voters wanted both simplicity and specificity about how it would work. But at the same time, we wanted to give this administration on the regulatory side as well as the legislature as much flexibility as possible to, as the process was implemented, once implemented, to make changes as we go in a way that both protected the medical system as well as the non-medical system.
Well, just in follow-up, I agree with that idea that over time you would implement it, but I see them as you actually provided a study provision out in the future for studies to be conducted to bring forward recommendations on how to further implement and refine. So it seems to me this is really a question about, I definitely see side by side, I see efficiencies, but you said streamline and consolidate, which you do when you put it in one agency, but then when you go to those provisions, it's 3.5 in this chapter throughout the whole thing. And then you have the study piece, which will bring a sort of reflective analysis in the future. I just feel we're sort of short-circuiting your plan, which jeopardizes your plan, because it's sort of upsetting the framework you established.
Well, I don't want to forget the fact that our plan, and I want to turn it over to a real lawyer here, but I don't want to forget that our plan required ending the criminalization of otherwise responsible adult behavior in California. So we started there. From there, we needed to figure out as much as we could do in a short period of time to protect both the regulators, consumers, local government, and law enforcement, but as well as create a efficient and legal marketplace so people could safely access this. And so, again, if I'm understanding, are you suggesting waiting would have been, or creating a longer time horizon? If that's so, that's why we had it. That's why we did it the way we did it. We also want to align the timelines.
I'm more suggesting that I don't think there's an urgent need to reconcile the two statutory programs at this time. I think you actually leave them in place, let them roll out a little bit. That actually supports your study idea, because you'll have one agency which knows how they thought through the issues, two parallel schemes. They can learn from how they roll out, and the lessons they learn as between Side A versus Side B can inform ongoing studies. And it also avoids the problem of one of your almost 36 references to 3.5 throughout 64, somehow that statute disappearing, or creating confusion as to if marijuana for 64 purposes does include non-medical, when you repeal 64, what does marijuana now include? Are we expanding the growth industry so you're now growing both sides? It just, to me, it might even be that you end up finding a way to just leave 3.5 on the books for a decade and have a sunset on it. So you know it's going to go away, but you don't lose that statutory input right away.
You might add anything to that? Okay.
But thank you very much. That's responsive. Thank you.
Thank you very much. Mr. Lackey.
Yeah, just real quickly, you probably heard my earlier question that has to do with the harvest tax. And I just wondered why it was structured in a way that could actually penalize some of these cultivators, because they have to pay taxes on products that may not pass testing.
Right. You want to jump in? Go ahead.
Thank you for the question. The initiative is very specific that the tax applies to cannabis that enters the commercial market. To the extent there is cannabis that is grown, for example, fails testing and never enters the commercial market, by its express terms, that would not be subject to the cultivation tax.
Thank you.
Mr. Jones-Sawyer.
Thank you. I had submitted a proposal, a bill, to help with local, especially Los Angeles, where I'm from, with local approval language. And I think right now it seems to be a little convoluted in the first tranche of what we're trying to do. I'm just trying to get a sense of local control and their regulation and the language there. I know in the message that he sent out, he didn't want to have, the governor didn't want to have two competing licenses at the same time. And at the time, I believe our bill would have helped clarify that. And so I want to get a feel for why you may not have used I guess it's Mercer, this is the longest, MCRSA model. We have a lot of smart people. We could have come up with something a little bit easier. But
In terms of dual licensing?
Yes.
Well, I will tell you that, I mean, there was some concern during the drafting, and we heard from hundreds of groups that there was the possibility. We did want to create a system where there's incentives for local compliance, and local compliance would lead to a first-in-line a position in terms of state licensing. But at the same time, we did not want to allow local jurisdictions to ban by another name, by essentially slow walking license approvals as a way to picking winners and losers in their jurisdiction, or to effectively ban overall. And so that was the idea of it. And anything you want to add to that piece?
No, the only point that I would add to that is the initiative is very clear that if somebody applies for and obtains a state license on the adult use side, they cannot use that license in a way that doesn't satisfy local requirements. So if somebody applies for and obtains a state license and they do not have a local license, and that's required by the local government, they can't set up shop and begin operations. The initiative does fully preserve local control in that regard.
Okay. Thank you.
Any additional comments? Mr. Wood.
Just a question, and this has come up, and I know I've brought this up before, but I'd like to hear from Ms. Boyer-Vine and also from Mr. Miadich, the understanding of the phrase, which I had never seen before, unreasonably impracticable. So I'd like to have Counsel just walk us through. Had you ever seen that before? I know I've talked to Ms. Boyer-Vine about this, and I'd like to hear from the folks on the other side too.
Yeah, I've worked on that issue a little bit and looked into that, and we don't have precedent for that. What is unreasonably impracticable versus just impracticable? So it's unclear. From our reading of it, what exactly that should mean, as opposed to just something that's impracticable. But we'll read, a court will read that as best as they can to see that there can be some certain barrier. But we don't have any case law to go off of, any kind of precedent to see how specific we should get. So it would be very fact specific in terms of the overall scheme of Prop 64, what the actual challenge would be to a specific regulation as being unreasonably impracticable, and that's where we can add for right now.
The term unreasonably impracticable actually derives from Colorado, which, as you know, is one of the first states to legalize cannabis. They use that term in their initiative that enacted those laws. We basically mapped that over into Prop 64. The concept that refers to is that keeping in mind that the ultimate goal here is to eliminate the illegal market for cannabis in California. Unreasonable impracticability would refer to a regulation that is so onerous that nobody could possibly comply with it. And if you can't comply with the regulation, you can't get above board, essentially, and into the legal market. It's going to continue to perpetuate the illegal market, which is directly contrary to our fundamental purpose. So the idea was to strike a balance in the regulations between strictly protecting public health and safety, but not creating such high barriers that you don't actually have the emergence of the legal market in California. And again, it derived from Colorado.
So I guess a follow-up, and just to try to understand. I guess when I first saw that, I wondered, you have an industry that has never really been regulated, and so to some people, unreasonably impracticable might be just about anything, and so that had a concern to me. So I guess the follow-up really is, how is it working out in Colorado, and what has the impact been on reducing the illegal market?
Yeah, based on our review that we did during the drafting process, there has not been a cascade or a flood of lawsuits challenging the regulations. It's been implemented in a very orderly fashion.
And I'd just like to add that there is also in the definition section of the initiative that it means that the measures necessary to comply with the regulations require such a high investment of risk, money, time, or any other resource or asset that the operation of marijuana establishment is not worthy of being carried out in practice by a reasonably prudent business person. So the investment of risk, money, time, or any other resource or asset would be help give some clarification, as we've already discussed. Yeah.
And then just curious, what was the thought process going into the specificity of the taxes? Because the legislature was actually working on things in 2016 related to that. So, and actually the processes that we were going through were actually leading to a different tax scheme than what was currently in Prop 64, actually lower taxes then. So I'm curious as to why was the specificity in the initiative around taxes, which now I believe would require a 2/3 majority to change, if at all. So I'm just curious why the specificity.
Well, it started with the premise of it's difficult. We knew that there were ongoing conversations led by yourself and others, some women would, about a reasonable tax on medical marijuana, and then the possibility of adult use. But it is very hard to pass. I know as a former legislative staffer, it is hard to pass tax increases, and we knew that was going to be easier to do in a ballot measure. And we needed the revenue to create the regulatory framework to oversee a brand new industry. So we brought in experts, including a few former finance directors, to review the materials and try to strike a balance between a tax. It was the Goldilocks principle of not too big, not too small. Try to make it just right, because if you tax too high, you create black market. If you tax too low, you don't get the revenue to actually offset the impacts, as well as you're allowing a flood of cheap product, which of course could have a negative impact on kids. We consulted with the Board of Equalization during drafting and other technical expertise from the administration, and that's how we ended up with the framework we did. Fundamentally, it was probably the area that had the most technical input throughout this process. But it's a tough one, because we wanted to create. It's the one area. It's hard. As much as we want to create legislative flexibility, we know when you come to tax thresholds, it's hard to do, because it's hard to change on a going basis. So we did. So that's how we came up with that.
Well, I know as difficult as it is, we actually in this House actually did do it and get it over to the Senate. Unfortunately, it died in the Senate, but we actually got 3/4 of the legislature to support that. So anyway, final question through the chair is the question I asked Mr. Murphy, and that's how do you feel about the fact that the administration now wants to take $9 million away from Fish and Wildlife, dropping below the 2014 threshold? That feels like a problem to me, because like I said, we're seeing this in other areas as well by the administration.
On that point, we're in agreement with your interpretation of how the initiative should be enacted, Assemblymember Wood. We believe that funding for those departments was intended to be in effect right away.
Thank you very much, Mr. Wood. Mr. Bonta and then Mr. Lackey.
Thank you for your presentations and for being here. I really appreciate it. The trailer bill language is intended to reconcile and harmonize some areas of conflict that exist between Prop 64 and MCRSA, and we also have a January 1st, 2018 goal for issuing licenses. There's no scheduled election between now and January 1st, 2018. So, and there are certainly some areas which I would suspect any legal opinion would say that going the way MCRSA had dictated as opposed to the way Prop 64 supports would not be consistent with the purpose and intent. So specifically things like vertical integration, independent distribution, verification of local permits. I think, and Counsel, please tell me if you disagree, that would need to go to the voters to change to be consistent with MCRSA as opposed to Prop 64. So can you tell me what our options are as a legislature if, in our wisdom, we believe that the MCRSA approach is the better policy approach on vertical integration, independent distribution, verification of local permits, those areas where there seems to be clear conflict between Prop 64 and MCRSA? How can we comply with Prop 64, comply with the law regarding propositions and voter-approved initiatives, and still make the January 1st, 2018 deadline?
In terms of practically how the administration and we as a state meet that January 1, 2018 deadline, I'm sure that's a question that the administration could speak to more in terms of practical terms. There is always going to be that option of going forward with the MCRSA as drafted and Prop 64 as drafted without creating legal conflicts. Where there are significant differences between the two initiatives, between the initiative and the MCRSA, including the ones that you pointed out, I do think it would be difficult to make the argument that conforming the structure chosen in Prop 64 to the MCRSA furthers the purposes and intent of the initiative, but we certainly wouldn't preclude anyone from making that argument.
And I'll just add on the vertical integration piece. It definitely depends on the specifics. So certain conforming changes can be made with majority, with 2/3, depending upon the specific proposal. But with vertical integration, we have a 26053 section of the Business and Professions Code that Prop 64 adds, and that says that the Bureau and licensing authorities may issue licenses under the division, and subdivision C says a person or entity may apply for and be issued more than one license under this division. So that's the barrier to say that to amend that and put in a cross licensure restriction would be in violation of that primary mandate within that subdivision. The only exception to that is that it's except as provided by subdivision B, and that has to do with the testing licenses. Of course, we've already covered that you can be have that cross licensure, and they do have that cross licensure restriction on testing.
I guess I would reiterate what Mariko said is you don't have to go forward in integrating these systems to be safe.
Any thoughts from our other panelists, Mr. Kinney or Miadich?
Well, I don't disagree with, I would never disagree with Ledge Counsel, with Counsel's interpretation of the limits. There's been clearly Prop 64 took a specific approach, but we took that approach after talking to folks that were advocating for and benefiting from both sides of both the open and closed distribution discussion. We came to the conclusion that early on in the process, based on what we saw in other states, that making a predetermination about market impacts, about what a horizontally integrated or vertically integrated system would cause and whether that would cause monopoly impacts in a supply chain, which I think we all agree would be disadvantageous and anti-consumer, it was hard to make that determination now. So the best way to do that was to allow the administration, who's not required to issue any licenses to anybody, but to make that determination along with very strict anti-monopoly provisions that requires them to make certain determinations about what does or does constitute a monopoly along the process. And that's ultimately why the measure reflects that. But again, we were careful not to attempt to impinge that or impinge upon what was in MCRSA. Anything to add to that? All right.
So it's been suggested that one option is to not seek to harmonize into a single system that applies equally to medical and adult use and have two side-by-side systems, maybe with different rules in these areas for independent distribution, vertical integration, verification of local permits. I mean, do you think that's a good policy or a policy approach to have the two side-by-side sets of rules that are different for medical and adult use?
Generally speaking, no, because the system will ultimately, as we've seen in other states, collapse upon itself. It creates this massive public confusion, for local enforcement authorities. And just overall is an inefficient way to operate a system like this. So generally speaking, we think that's not a good outcome.
But it is how you drafted it.
Well, you are correct that we did not want to presume to replace our judgment with the legislature and the governors when it came to medical cannabis. But ultimately, we are talking about the same product. And there are differences. There are tax consequences that are different. There are purity considerations when you're talking about sick and legitimately sick patients. There's the impact on the health system when it comes to medical. The ultimate goal of Prop 64 was to strengthen the medical system so that it was primarily serving legitimate medical patients while creating an alternative for otherwise responsible adults on the adult use side.
Mr. Lackey and then Mr. Cooley.
Yeah, it was mentioned earlier that the administration's proposed limiting the Type 3 cultivation licenses. And do you believe that's consistent with the intent of Prop 64, or would this need to go back to voters?
Yes, it sounds like a lawyer question to me.
I think it's a lawyer question.
Yeah, we believe that would be a 2/3 vote. We would key that, and that would not be furthering the purposes, because the limitation is not would be a restraint on the policy. There's one of the findings of the purposes intent is to reduce barriers to entry, and so it could be interpreted that this is creating a barrier to entry if you're limiting those Type 3 licenses.
This is a question that maybe would be productive amendment to the trailer bill. And I'm more to suggest your view of how this might work. There are advisory committees under both MCRSA and under Prop 64. Clearly under MCRSA, it includes sort of access issues, which gets into affordability, which is one an underlying concern of the original Compassionate Use Act. The advisory committee under MCRSA is a little more focused on implementation of the commercial. I'm wondering, would you think it would be compatible with the framework of Prop 64, as you understand it, to include somebody whose perspective would focus on affordability and access issues, and then more generally expressly include some coverage for folks to reflect California's racial, ethnic diversity, economic variety of folks, just to kind of broaden the conversation a little bit at the advisory panel on accessibility and diversity and those sorts of things. Would an amendment like that, do you think, be consistent with that, such that we could do it?
Yeah, I do want to say one thing about the advisory committee, which is I heard you say that earlier about that it's more commercially oriented. It is true that we suggest that there should be some industry representation, business and labor, as well as public health experts, state experts, local government experts. But that shouldn't be misinterpreted as an outsized focus on commercial activity. Creating a new commercial, legal, regulated market is an important part of 64, but it doesn't. Was not the driving force for most of the folks who helped write it. The decriminalization of social justice aspects were more important, and so your suggestion about access and affordability is important. It was a concern for many of the groups that were involved in this, as well as the reference to diversity. Prop 64 is written, unlike any marijuana measure in the country, had very specific provisions encouraging and specific money, encouraging job creation, training, and recruitment and awareness by communities that have been disproportionately impacted by the failed war on marijuana. So it perfectly stands to reason that they would be represented on the advisory committee. I would point out that the advisory committee had no limits on how many the governor's office could, or the administration could appoint, because we wanted to create maximum flexibility to allow them to make decisions about having a representative and diverse panel that reflects the face of California. Anything to add to that?
Well, the only thing I would add from a legal perspective, the way the provision is written, as Jason just mentioned, there are certain representatives that are explicitly spelled out, but it is including and not limited to. So to the extent that the legislature or the governor wanted to add additional folks, that authority already exists under the current construct. You wouldn't need to amend the initiative to do that.
Mr. Wood.
Yeah, just a question, just another question. And first of all, thank you. You've been very open about your intents, and I really appreciate that. I'm curious with relation to the taxes, because it was a big part of the initiative of the $1 billion that was going to go to a lot of different programs. How did you envision the taxes being collected? Because that's a problem for us right now, trying to figure out how we actually collect those taxes.
So you're right. That's certainly one of the issues that we spent a considerable amount of time thinking about during the drafting process. The initiative, as currently constructed, and as Jason mentioned, we drafted that section in consultation with BOE, doesn't seek to explicitly define how they will be the taxes would be collected. It assigns responsibility for the taxes. So a cultivator is, of course, responsible for the payment of cultivation tax. Retailer ultimately responsible for the payment of retail taxes. Instead, what the initiative does is it empowers the Board of Equalization to define the specific manner and mechanisms for tax collection. So under the initiative as it was drafted, envisioned that would be something that BOE would be doing going forward.
Thank you very much. Any additional questions or comments at this point in time? Thank you very much for your time and commitment, and particularly I want to thank Ms. Boyer-Vine and your team specifically for making yourselves so readily available on this issue and on many other issues as well too. So thank you very much to you and your entire team. We'll now then head into our final portion of the agenda before getting to public comment. So we now go to the regulatory process and fiscal impact. I'd like to call up Dean Grafilo, Director of the Department of Consumer Affairs, and Lori Ajax, Chief of the Bureau of Medical Cannabis Regulation. And Mr. Grafilo, maybe perhaps you can start if you have any opening comments, and then we'll go to Lori.
Good morning, Mr. Chair, members. I'm Dean Grafilo, Director of the Department of Consumer Affairs. I'd like to make a few introductory comments before I turn it over to Lori Ajax, Chief of the Bureau of the Medical Cannabis Regulation. But before I do, I'll mention that it's only been 2 months since I left my previous role as Chief of Staff for Assemblymember Rob Bonta. In addition to thanking Governor Brown for appointing me to DCA, I'd be remiss if I didn't express my deep gratitude and appreciation for the nearly 10 years I grew and learned in the Assembly. Working with many of you on MCRSA and other pieces of legislation was an extremely rewarding and memorable experience. Thank you. First, I would like to thank you all for allowing us the opportunity to discuss our ongoing work related to cannabis regulation. As you know, the Bureau is under the oversight of the Department of Consumer Affairs, and at the end of April, we released an initial draft of the medical cannabis regulations. While these regulations represent our initial approach to ensuring consumer protection in the cannabis industry, we recognize that we alone do not have all the answers. To that end, beginning in June, we will be traveling across the state to receive public feedback that is so critical to this process. As we continue to develop and modify these regulations, I'll mention just a few of the many issues of importance in my view. It is my understanding that with many of you, we see eye to eye. Our common ground was likely born, identified, and refined over the thousands of hours towards shaping MCRSA. First, the department will do everything in its power to ensure that cannabis and cannabis products stay out of the hands of children and minors. This includes prohibiting advertising and products that are marketed to minors and enforcing strict labeling requirements. Second, regarding suitability and previous convictions. I am sensitive to the fact that many likely applicants, particularly individuals from communities of color, may have previous cannabis-related convictions. For this reason, we must be mindful to develop regulations that are in the interest of equity and do not unnecessarily limit opportunities for all. Lastly, and perhaps most importantly, as the primary consumer protection advocate in the state, I will do all that I can to ensure that cannabis and cannabis products are rigorously tested and deemed safe for consumption. To be successful in these areas, I will look to partner with the legislature, local governments, law enforcement, all shapes and sizes of the industry, all other stakeholders, and continue to work with our other agencies, including CDPH and CDFA. Again, thank you all for this opportunity. I'll now turn it over to Lori Ajax, Chief of the Bureau of Medical Cannabis Regulation.
Mr. Chairperson, committee members, and staff, thank you for the opportunity to address you today. My name is Lori Ajax, and I am the Chief of the Bureau of Medical Cannabis Regulation. The Bureau has noticed and is currently in the comment period for its proposed regulations for the Medical Cannabis Regulation and Safety Act. The Bureau has proposed the regulations in 2 individual regulatory packages. The first package has the proposed regulations for the general requirements applicable to all Bureau licensees, distributors, transporters, and dispensaries. The comment period for this package ends on June 13th. The second regulatory package contains the proposed regulations for testing laboratories. The comment period for that package ends on June 20th. For both packages, the Bureau will be holding hearings in Eureka, San Jose, Sacramento, and Los Angeles. The Bureau will also be accepting written comments in hard copy or electronically during the comment period. I'd like to highlight some of the key provisions of the proposed medical regulations for you today. In order to ensure that there is no interruption in a patient's ability to attain medical cannabis, businesses who are in operation by January 1st of 2018 and are operating in compliance with all local and state laws may continue to operate while their state application is pending. Additionally, for continued operation, the applicant must submit an application to the Bureau prior to July 2nd of 2018. Some medical cannabis businesses may be entitled to priority licensing. In order to receive priority licensing, the regulations require the applicant to be able to demonstrate they're in operation and in good standing with the local jurisdiction by January 1st of 2016, and the ownership or premises are the same as on January 1st of 2016. The proposed regulations deem ownership as any person who holds at least 5% of a publicly traded company, holds at least 20% of a non-publicly traded company, or participates in the direction, control, or management of the business. The proposed regulations provide a number of security measures that will be required for all licensees. Licensees will be required to provide all employees with employee badges and require that the badges be worn at all times while on the licensed premises. Certain areas of the licensed premises must be designated as limited access areas and must be kept secure. All medical cannabis goods must be stored in a secure manner. Additionally, security personnel, 24-hour video surveillance, alarm systems, and commercial-grade locks are required for all licensees. Licensees are required to report to the Bureau and law enforcement within 24 hours of any theft or loss of medical cannabis goods. Under the proposed regulations, distributors would arrange for the testing of the medical cannabis goods as well as perform other quality assurance functions. Distributors must store cannabis goods by batch and under specified conditions to prevent degradation of the medical cannabis goods. Distributors may package and label medical cannabis that is in the form of dried flower. However, distributors may not package or label any manufactured medical cannabis goods. Licensed transporters physically transport medical cannabis goods from one licensee to another. Transporters are not allowed to take ownership of the medical cannabis goods they are transporting. During transportation, all medical cannabis goods must be transported in a vehicle or a trailer, must not be visible from outside of the vehicle, and must be kept in a locked box during transportation. All transport vehicles must be equipped with an alarm system and must be secure at all times. Each transport of medical cannabis requires a shipping manifest containing the transport information within the track and trace system, including the name of the licensee, the driver, the type and quantity of medical cannabis goods being transported, vehicle information, the start and end locations, and times of transport. Any person in the transport vehicle must be at least 21 years old. A transporter may not store medical cannabis goods at the transporter's premises for longer than 72 hours and must store cannabis goods in the same manners as distributors. Licensed dispensaries will sell and deliver medical cannabis to patients. Under the proposed regulation, all medical cannabis goods, including flower, must be properly packaged and labeled prior to being transported to the dispensary. Sales and deliveries of medical cannabis goods are required to occur between the hours of 6 a.m. and 9 p.m. Dispensaries are not permitted to give away free samples of cannabis goods and may not sell any medical cannabis goods that were returned or have exceeded their expiration date. Prior to leaving the dispensary premises, all purchases of medical cannabis goods must be placed in exit packages, which are opaque and difficult for children to open. Deliveries are required to be made in person to a physical address, and delivery employees must be at least 21 years old. Delivery vehicles may not contain more than 3,000 of medical cannabis goods at any time, and the dispensary must be able to identify the geographic location of all active delivery vehicles. To allow for medical cannabis to be available during the transition to state licensing, medical cannabis goods that have not been tested pursuant to the requirements of MCRSA may be sold for 180 days after licensure or until December 31st, 2018, whichever is sooner. However, the product must be properly labeled, indicating that the product was not tested as required under MCRSA. Licensed testing laboratories will perform a variety of tests on medical cannabis goods in order to ensure that the medical cannabis goods are safe for consumption. All medical cannabis goods are required to be tested prior to being sold to patients, and detailed records of the testing procedures are required. Under the proposed regulations, samples will be taken from each harvest batch to be tested. Licensed testing laboratories are required to test all medical cannabis goods for the following substances: cannabinoids, residual solvents and processing chemicals, residual pesticides, microbiological impurities, mycotoxins, water activity and moisture content, filth and foreign material, and heavy metals. The proposed regulations indicate the acceptable levels for each substance. Additionally, edible medical cannabis goods will be tested for homogeneity to ensure the consistent concentration of THC or CBD within the product. Upon completion of all the required testing, the licensed testing laboratory will issue a certificate of analysis containing the results of the testing. Batches that pass the testing may be sold to dispensaries for sale to patients. Any batches that fail testing must be destroyed or undergo remediation. Prior to retesting a batch that has previously failed, a description of the efforts to remediate the product must be provided. Testing laboratories are required to regularly prepare and test quality control samples for each method of test performed, participate in proficiency testing to ensure laboratories' testing methods are being performed correctly, and ensure personnel have specific training and education. Licensed laboratories are required to obtain ISO accreditation. However, under the proposed regulation, testing laboratories may obtain a provisional license that would allow them to begin operating while awaiting this ISO accreditation. That is a brief overview of our regulations. Thank you for your time and attention, and happy to answer any questions you have.
Thank you very much. Any questions at this time for any of our presenters? Mr. Lackey.
Yeah, I have a question about products and being tested in the final form when they're offered at retail. As you may be aware, the McCursa regulations include this requirement, and we just want to make sure that is it put into statute for recreational as well.
Under AUMA, the testing requirements are very similar, and our regulations will be very similar also. And they will be tested in their final form before going to the dispensary.
Mr. Steinhorst.
Thank you very much for testifying today. I just have a couple questions on a few topics. One issue that's increasingly threatening public safety is the use of volatile solvent extractors to produce cannabis concentrate. Last week, the Assembly passed AB 238, which seeks to prevent the use of these solvent extractors from residential and mixed-use buildings. The proposed trailer language deletes the definition of a volatile solvent, which previously included butane. Is the administration planning on replacing the definition of a volatile solvent or making any other steps to limit the use of extraction systems in neighborhoods?
So I am here. Unfortunately, I can't answer any questions on trailer bill, but I can answer any questions you have on the Bureau of Regulations at this time.
Okay, very good. Thank you.
Mr. Wood.
Thank you, Ms. Ajax and Mr. Grafilo. Just a question, because I asked it of Brendan Murphy earlier, and that was, and you covered a lot of it around transportation, but the one question I had was, are you going to require a commercial license to deliver cannabis at this point?
I think right now we're looking at, under the trailer bill, adding language that makes it very specific. You have to be a licensee in order to transport.
What kind of a licensee? Because I'm hearing we're not going to have a transportation license. So what do you mean by a licensee?
That you'd have to at least have a licensee in one of the other categories, either a manufacturer or cultivator of commercial cannabis. As for requiring them having a commercial license, that is certainly something we're open to adding to the regulations.
I wasn't suggesting it. I was just curious. But thank you for that. So, as you well know, I represent the North Coast, which is a lot of very, very small growers, and I was curious: is there what are the efforts? Are there any efforts to help? I guess my concern is in time, larger, more sophisticated operations with lots of potential resources will come, and that's natural, and that's natural in the process, and I completely appreciate that. But it is hard. I think it's going to be really difficult for the really small growers who are struggling to try to come into compliance to be able to do that. So how are you approaching that as far as? I can just envision, I came from a pretty regulated business as a dentist, and just the time it took me to understand all the things that I was responsible for in my practice around hazardous materials and all labor laws and all these different things. So I guess my concern is that we're going to be throwing a whole lot of things at people all at once, and how will the Bureau actually work to help it, so that it isn't so incredibly overwhelming, because the goal is to get people to come in. The carrot's much better than the stick, from our perspective, and that was what I appreciated by what the Water Board was doing with their regulations and moving forward with that. And so are there efforts in that? Because I know that each of the individual agencies is communicating with people, but it doesn't feel really coordinated. So and that's, I think, potentially going to be confusing to people. So can you help with some thoughts on that?
So it has to be a coordinated approach, and between the Bureau, Public Health, Food and Ag, Water Boards, we have to do that outreach. And I think it starts first with the locals and making sure the locals understand our regulations, what we're putting into place, and so they're aware of, and then working through them to get out to the folks that are already currently, whether it's the growers, the dispensaries, and making sure we are communicating what our application's requiring, when they can start applying for a license. And I agree with you. We can always improve on making sure that educational coordinated effort, especially once we get our licensing systems up and running, and hopefully we're going to be ahead of that before January 1st so we can start taking applications. And so we are all preparing on getting our staffing levels at an appropriate level in early fall so we can do that coordinated outreach. It would help to have all of our final regulations in place and know where we're going. And I think once we get past some of the trailer bill and we get our adult use regulations, it'll be a lot easier to have those conversations and do that outreach, because we'll have a better idea of what those final regulations will look like.
Well, and I would, and I've said this at every forum I think I've been at, the more we can communicate with people, the more we can do that, the better. I think it's got to be incredibly overwhelming for folks that have never really followed under any regulatory scheme. And I know there are people who really want to do the right thing, so it's not. There's always good people who don't. We know that, and in my profession as well. So, but I hope we can, it may be some hand-holding. I can't think of another way to say that as we move through this process. But the goal is to get as many people to come into compliance as possible. So my plea is anything we could do to help that process would be great. Thank you.
Absolutely.
Two cents to that, Dr. Wood. I share that as well. And from the department's perspective, if you envision town halls, because obviously much more interactive than someone going to a website and trying to sift through mass amounts of information. If that's something you're interested in doing, and
anything in things along those lines, and if we're also going to be relying a lot on internet technology, just remember we don't have a lot of that up on in my area, and so there's folks that are off the grid and don't have access. Cell phones don't work. We don't have broadband, and so it creates a real challenge around that. So, one other question, which I don't know if it's come up in anything else, is how do you plan to collect the fees for the licenses? Because right now there's no banking, so. And some of the license fees are significant amounts of money. And so how do you plan to collect the fees, and where do you plan to collect the fees? One license category is $38,000, as I recall. That's a lot of cash to carry around. So I'm just curious.
So the Bureau, currently, we're going to be collecting fees at our headquarters office in Sacramento, and at this point we're in negotiation for a new facility in Sacramento County, and so we're making sure that we are going to have cameras, security, vault, all that for collecting cash. We may even look at partnering with, public health. We may be accepting cash on their behalf too. We're still looking into that, and then we're trying to look at the feasibility of other boards and bureaus to leverage some of their regional offices. And trying to see if that's feasible to be able to accept cash at other locations.
Mr. Jones Sawyer.
Hi, and I appreciate you both being here. And I know last time, Ms. Ajax, and we talked about diversity and getting more people involved. And I know Dean, I'll take him on his word that he wants to open it up. I mean, it wasn't until now that I didn't realize he had a last name. He was always Dean. And irrespective of who you used to work for, who I also admire, it is still a problem. I know Mr. Ajax and I talked about having some kind of town hall or something in my district. I see you offering town halls in all the other assembly members' districts. My office called your office. I have this saying called passive-aggressive racism, where you talk a good game, but your policies and principles are inherently racist. My office called your office, and I know we talked about you coming to my district to talk to African American Latinos about what we're doing in the cannabis. And I know beforehand the NAACP was on you because you had conferences downtown, and that doesn't work, especially if you're trying to get a lot of African American Latinos to go to the Ronald Reagan building. That can be a problem. We did contact your office, and I know sometimes your staff can sabotage you, and so I want to make you abundantly aware of that. We found a place. We said we wanted to be there, and guess what? They said we need to meet downtown at the Ronald Reagan building, and not in my district, not in East LA, not in South LA. And so I'm going to try again to offer my help so that we can get the information out of what's going on, so you can get input from people from disadvantaged communities, poor people, immigrants, African American, Latinos. Make that offer again so that we don't have this interaction again, so that we can have a dialogue that includes everyone in California and that everyone has a voice. And now that I have Mr. Grafilo there, I'm hoping that he can get to his staffs so that we can make that happen. Otherwise, this whole discussion about diversity, I think we're just having a discussion, and we're not really getting to the crux of how to make this industry as diverse as possible and how we can include everyone in it, because I firmly believe it's a great business. And so let's just, and I have another question, but let's just start with just something very simple, which is having a town hall on this with your departments coming in to talk about it in in a district that isn't always looking like the same people who are involved in this business, which are not mostly African American and Latino. And so if I can somehow get someone to make that commitment, that would be great.
Mr. Jones-Sawyer, I'm not familiar with obviously the back and forth that you alluded to.
Mm-hmm.
Sorry to hear that you had that experience. I will personally commit to ensuring that DCA and the Bureau is in your district to address your community specific to this issue.
Okay, thank you. And then my second, my colleague to my right, we've been working, and actually the Five Amigos, we've been working on not leaving out, well, actually we want to know why the administration did not include any kind of drugged driving provisions in this proposal, but more importantly, why did it repeal the UC San Diego DUID study? For us, it was very important so that, as the chair of public safety, that we didn't put forth ordinances or laws that didn't make any sense. And we thought putting up to $3 million for that study was real important. But more important, that we continue the study so that we have as perfect a system as we can, so that we don't go back to now arresting people who now have an opportunity to have adult use marijuana, legally use it, and then because of improper testing, we're now throwing more and more people back in jail again on marijuana. And so I don't know if you know why the studies or our ability to figure out how to properly test people was kind of left out, or as a second thought, or is that something you want us to do? I'm not certain.
I'm not sure why it was left out, but the study will continue to go on. We have a contract with University of California, San Diego. It's a 3-year study, so that will continue. Not sure why it's not in the trailer bill.
Well, hopefully they can get it done quickly. I'm hearing they're having problems getting marijuana from the feds. They can come to my district. I mean, we can help them out with that. They don't have to go that far.
They have gotten the cannabis, and they started conducting the study. Yeah, they have to go through quite a process to get.
I hear it's a very convoluted process. Yes.
Mr. Cooley and then Mr. Bonta.
A couple of quick comments by way of actually segueing off both issues my colleague from Los Angeles just raised. On the general issue of diversity, I'm reminded that it was this committee, Business Professions Committee, that 3 years ago we started the medical marijuana conversation in this very room. And as you say, the Five Amigos, we worked on that. And an aspect of the legislative process when we were involved is we were able to bring a lot of people with us. And that sort of is what undergirded progress in 2015, the ability of lawmakers to engage in a conversation, bring people along. So I think on issues of diversity, working with the legislature on substantive policy helps. It can seem sometimes a more efficient route to just do the regulation, but you actually lose something in terms of how we bring along all kinds of communities to make progress on a conversation. And so then the placeholder I just want to say is there's a lot of regulations that are out there that might actually be served by being brought into the legislative process and doing some of this work by statute, because then you end up having a group of champions who can carry the argument and explain it and lend it some bona fides that it reflects a broader community. So I know regulation can seem efficient, but I think in terms of advancing the conversation, it's not as efficient. Related to that, I just want to say at the conference last week, I heard from Dr. Igor Grant of UCSD on this issue of these studies, and he emphasized how the science is unresolved. Unresolved questions regarding public health and safety impacts of medical cannabis, e.g. driving. He had a lot to say about these studies. So to lose that in the statute, I think is, even though the study's going to go forward, I do think we're losing, it sort of backs us up in a wrong way. So if you want to comment about statute regulations and statute? And then I would just like to hear, what is the administration doing to ensure access for low-income patients of medical cannabis, which we've talked about a lot, Ms. Ajax. So on the issue of statute versus regulation and access to low-income, I'd appreciate some comments, and thank you for your time and being here, both of you.
So I defer to you if you we were tasked with, under both Medical Cannabis Regulation and Safety Act and AUMA, to develop the regulations to further define the law. But in those areas where the legislature feels it's more effective to be in statute, that's not up to me. So I'm perfectly fine. Just wanted you to know that we are trying to cover those things that aren't in statute through regulation. So we're just there to fill in where we need to on that. As for what the administration is doing on low-income patients, I think that is still being worked out through trailer bill language that I'm unable to comment today.
Thank you very much. Mr. Ponto.
Just following up on the discussion around equity and inclusion and providing opportunities for historically disadvantaged communities to participate in a new, emerging, growing industry that has really had adverse impacts for them in the past because of the way we overcriminalized. You came down and we had a great conversation with some folks in Oakland. I appreciated your presence and your engagement and your active listening, as well as your contributions to that discussion, Ms. Ajax. And I just wanted to see if there were some things that came out of that discussion, or maybe others that you've been having in different places in the state about the same issue, which is so important to so many of us, that you are thinking about or maybe have already started implementing as ways to remove unnecessary barriers and provide more opportunities for some of these disadvantaged communities.
Yes, and I appreciate that, and I just want to follow up with Assemblymember Jones Sawyer. We have been working very diligently with your staff to try to put something on the calendar, because I believe we do have to be all over the state. We can't just be in one area talking about these issues. We have to be accessible everywhere. And as for not going back to the downtown location, it was really just trying to get a date that was available that we could do those regulations hearing, and there was just a conflict that we couldn't get to the science building, and I apologize for that, but I fully expect to be down and holding any town hall meeting or diversity forum, and I will make sure we are communicating that with your staff on a constant basis. But as for talking, I thought the forum that we had, Assemblymember Bonta, was very, it was a small group. I actually learned a tremendous amount, because I think just talking and communicating in that kind of, it was a small forum, was very helpful. I think it was helpful to have the GoBiz people there, because it's not just about the Bureau, it's making sure we're all the licensing authority, GoBiz, all the different state agencies are involved, because I think it's a broader conversation with other state agencies, and it's a broader conversation with the local jurisdictions. I don't think it's just us. It has to be hand in hand, because a lot of what they're doing at the local level affects what licenses we can issue at the state level. So I will say this, I think it's all of our having those conversations and continuing that and coming up with some strategies to make sure that we are making sure that folks that are underrepresented have a seat at the table and can be involved in the cannabis industry in various different ways, as workers, as owners, and whatnot.
Thank you. No, I appreciate that. I think the format was actually very productive and helpful as well, sort of a smaller roundtable of folks who sort of live in that equity space and were prepared to provide constructive input on how the state can move forward. A couple of things that I thought were particularly helpful that came out that I'd ask, if you're not already, to consider for implementation was advancing the Community Reinvestment Fund and using it to support cannabis entrepreneurship for communities that have been historically disadvantaged, specifically incubator programs and equity outreach programs We discussed that at the roundtable. Also, lowering the barrier for entry for non-storefront dispensary and delivery, which right now is one segment of the industry where there's growing opportunity for the disadvantaged communities that we're talking about. So I think that's a place to really take a close look and see if we can help boost opportunity instead of close doors. And then finally, of course, on the advisory committee and the appeals board, absolutely critical, I think, to all of us that we have a diverse group representing the various voices throughout the state, and have a good cross-section of representation there. Through the chair, I have another question, if I may, on a separate topic. Okay. Moving to self-distribution, can you talk a little bit about how the Bureau will ensure that licensees are compliant who are self-distributing? And will that be heavily reliant on track and trace, or will there be other ways to make sure that self-distributors are complying with all the quality assurance and quality control components and other requirements of their work?
Track and trace is one tool that we'll have to look at that, but we won't rely solely on that. It'll be doing compliance inspections, audits, investigations, and working with our sister agencies and local law enforcement. So I think between all of those things, that's how we're going to move forward with making sure the quality assurance and the testing taking place and making sure patients are getting safe product.
Thank you.
Thank you very much. Any additional questions or comments at this time? We very much appreciate your presentation and your presence here today. Thank you very much. Now for the final portion of the meeting. This is a portion for public comment. Would any member of the public wish to comment or provide any thoughts on any issues? And now would be the appropriate time, and we'll limit any comments to up to 1 minute. So if you have any comments that you'd like to share with members of the committee for the purposes of this informational hearing, please feel free to come up to the microphone. And again, you'll have up to 1 minute. So feel free to please just identify yourselves with your name and affiliation.
Great. Thank you, Mr. Chairman, members of the committee. My name is Corey Brown. I'm an attorney with the Resources Legacy Fund. We had the great pleasure of working with Mr. Miadich and the sponsors to help draft some of the environmental provisions that go into Proposition 64. I want to thank Assemblyman Wood for his very astute comments on the budget issues. Proposition 64 was designed to help get at a $700 million problem that we currently have and trying to keep that from getting worse in terms of environmental damage that's occurred due to illegal, unregulated marijuana. The measure includes several provisions, one of which is the budget provision that Mr. Wood had mentioned. And yes, as Mr. Miadich had mentioned, the budget provision should take effect in the 2017-2018 budget, and the current governor's budget proposal is $9,008,000 short of the requirement from Proposition 64, and we've addressed that with the budget committees, but I wanted to point out that particular issue. The other thing, picking up on what Legislative Counsel mentioned, changes to Proposition 64 need to be consistent with and further the purposes of Proposition 64, one of which is to protect the environment. As you see in the sheets that are being passed out, the proposed budget trailer bill actually repeals some of the environmental requirements and protections in Proposition 64. Those repeals and those changes are inconsistent with the purposes of Proposition 64, and we're urging the legislature to retain those very critical provisions of the ballot measure. That concludes my comments. I'm happy to answer any questions.
Thank you very much. Next member of the public.
Good morning, Chair and members. My name is Derek Dolphy from the League of California Cities. I am filling in for Tim Cromartie today, who is ill. He asked me to speak on his behalf. The League, along with the police chief, have raised numerous concerns with the proposed trailer bill. Concerns including the repealing of the definition of volatile solvent, the repealing of the state medical ID card program, and the ambiguity around the effect of revoking a local permit, just to name a few. We understand the evolving conversation to reconcile the MCRSA with Prop 64, and we will continue to work with stakeholders in this process. The League will remain in opposition to this trail bill unless our concerns are addressed and local control and enforcement is preserved. Thank you very much.
Thank you.
Hezekiah Allen on behalf of the California Growers Association. A number of things to touch on in 1 minute. I'm going to talk real fast. With regard to transport and transport licensing, the concept of tiered licenses for transportation was something you considered in 2015. I think that it deserves dusting off to solve some of these problems. Section 26053, a licensee may apply for and may be issued, does not say shall be issued, and it certainly doesn't say shall be issued every license they apply for. So the difference between complete free market, any license, every license, and reasonable limitations on vertical integration, there's quite a bit of difference there. The very strict specific anti-monopoly language contained in 26051 is subject for repeal because you could say it's unreasonably impracticable to implement as written because it's not actually specific enough. And so the anti-monopoly language in Prop 64 itself is slated for repeal under the trailer bill. Going to need to address that. Hope that you guys are working on that. With regard to taxes and the lack of clarity there, Section 34012 of Rev and Tax provides that after the product is harvested, it will be taxed. No products can be removed from the cultivation premise. It's presumed sold if it leaves the farm, but no product may be sold unless it's taxed. And so you're starting to perhaps see the circular logic on the cultivation tax there. It's absolutely not clear at all, and it does need addressing, and we welcome you in dealing with that. Reviewing the intent there, there's a broad goals in this proposition. You guys have a lot of room to amend, I think, within the intent, and strongly encourage your efforts to do so today. Applaud the MCRSA authors for their leadership and this committee for making this work. Appreciate your time. Thank you.
Thank you very much.
Likewise, Dale Geringer with California Normal and co-sponsor of Proposition 215. We're particularly concerned about the issue of access for patients, especially poor patients. We want to make sure medical cannabis is affordable and that the tax exemption is available to patients. So if the ID card system goes, then we do want to make sure that they can get it by getting there with their doctor's recommendation or not. The trailer bill language is vague and ambiguous on that point. We're also, in general, we're concerned that there's going to be a tendency for people to move towards the more flexible ORMA system as opposed to the less flexible MRCSA rules, and we're afraid that that will make the medical market possibly dry up. So we would like to see some unification of those rules, but we are disturbed in the trailer bill by the separation, the physical separation of adult and medical premises, where we know that a lot of medical licensees out there now are going to turn to adult use. And it would be a shame if they could not also sell medical products to their existing clientele. So we hope that that restriction can be eliminated, and we do applaud the notion of having non-storefront dispensaries. Thank you.
Thank you.
Mr. Chair and members, Amy Jenkins with Platinum Advisors on behalf of the California Cannabis Industry Association. I too want to applaud the authors of the MCRSA. CCIA worked very, very closely in the crafting of the medical framework, but also worked very closely in the crafting of the adult use framework and strongly supported 64. To that end, we also strongly support the trailer bill as written. We have been engaged in a lot of dialogue with the opponents and those that have concerns. We certainly think there is a path forward to reconciling all of the concerns, but do think that the trailer bill addresses a lot of issues that were raised by the industry throughout the discussions when we were negotiating the medical framework. One thing that Mr. Geringer noted that I'd like to echo is the co-location prohibition, as we refer to it. So the trailer bill does have a prohibition where you can only operate a medical or a recreational facility. We do think that's inherently problematic. We think that that will result in more operators choosing a recreational in lieu of medical model. It's also very costly for operators who want to do both to apply for different licenses. Manufacturing, for instance, takes millions of dollars to establish. So we would like to see the co-location prohibition changed, but overall are very, very pleased with the language in the trailer bill and urge your support going forward.
Hi, Katie Maple on behalf of the California Cannabis Couriers Association. We have a support, if amended, to include a non-storefront delivery license type. We applaud Assemblymember Bonta and the committee for asking questions about non-storefront delivery, and we look forward to working with the administration and with the Bureau on including that. Thank you.
Thank you.
Mr. Chair, Robert Harris on behalf of SEIU California. That we're in support in concept and not the final form of the trailer bill language, and so you understand where SEIU is coming from. One, a bunch of our members do the tax collection, the regulation, and we want to see that move forward. Two, the Community Reinvestment Fund goes to the neighborhoods where our members live. And so getting the taxes collected and rebuilding those neighborhoods is of critical import to us. Three, we have people in public health departments all over the state and members who work in mental health and substance abuse treatment, where the tax money is going to create, for the first time in the history of California, a treatment system for youth. We've never had any. And so we want to make sure the taxes are collected and that system is created in a good way that's sustainable and keeps youth out of drug abuse and make them successes in their school and in life. So those are the things that are driving our involvement in this, and we're working our best to make sure that you guys and the governor's office come together with a good product that makes this function and makes the taxes collected as rapidly as possible. Thank you.
Hi, Max McAlonis on behalf of the Los Angeles Delivery Alliance and Quantum Management Company. We'd like to echo the comments in support of the non-storefront dispensary license as previously stated by the Couriers Association. Furthermore, we'd like to express support and build on the co-location comments. There's a concern that we've currently been proposed unitary regulations but parallel supply chains. Without allowing for a unitary supply chain up until the dispensary level, there's a chance for market failure at the dispensary level, whereby there would be storefront dispensaries or adult use dispensaries licensed in January of next year, but no adult use cultivation, manufacturing, or distribution that's authorized. By combining supply chains, we can go and ensure that medical products can be found on adult use shelves with the same license. And so there's a concern on supply chain that we'd like to see rectified. Thank you for your time.
Thank you very much. Any final questions or comments? Seeing none, thank you very much to our presenters and members in balancing out Prop 64, the policy arena of this item, and also the governor's proposal. Thank you very much.